good. Hello, Chris. Your graphic came out great, guys. Brann Isaacson team. So we've got 16 folks in so far. We'll give everybody a minute to get settled. I'm going to mute everybody just as we get started. There we go. And as folks get kind of acclimated to this, I'm going to invite you to look down at the bottom of your screen, and there is a chat function in the middle. If you push that, then we can talk with each other. I'm going to give it a test run for everybody. This is how we're going to make sure we ask questions without talking over each other. So if you want to give it a test run, type hello and let us know that you're in there. You're welcome, Michelle. Great. That's fantastic. Thanks, Chris. Good job, team. So I'm going to give us maybe just another minute and then we'll get underway. As you get settled, just because of the group size, I'm going to start us all on mute, but we can unmute, and I haven't taken it away from you to be able to unmute yourself. So if you don't know yet and you're joining by video, you can unmute on the bottom left hand of your screen. You'll see a little microphone. And it should be red right now, but you can unmute yourself if you'd like. It'll be easiest if you guys ask questions in the chat box. And we'll be forgiving, right, of spelling errors today, mine included. We are recording this so that we can share it with others after today, because we know this time doesn't work for everybody. Looks like we're up to 17 participants. Welcome, everybody. And as we go through, you can ask questions in here. I'll be moderating to help out with our presenters. And I'm going to introduce them in just a moment. Morning, Leslie. Afternoon, I suppose, just by a little bit. I think we're doing great. Okay. I'm going to get us underway. It looks like we just had one more person join. Welcome. And I'm starting everybody on mute. I see there's a couple folks who are joining just by phone. We aren't going to do any screen sharing today, so there's nothing that you're going to miss. We do have a couple documents that we're going to email out to everyone who registered today by way of follow-up. And this is recorded, so we'll be able to give you a link to a recording as well, in case you would like to see our talking heads as the hour rolls on. In terms of format, we're gonna I'm gonna introduce in a moment our attorneys from Brann Isaacson, and they're gonna give an overview of some of the changing impacts of the coronavirus and public health pandemic as it relates to a couple of key portions of general law. And then we're gonna take your questions and really dig into some discussion at the end. Hopefully that sounds good to everyone. And so I'll get us underway. Since its founding over 90 years ago, Brann Isaacson has provided practical and high quality advice to businesses and public entities in Maine and around the world. They're longtime chamber members, which we're grateful for, and sponsors for the Top Gun program. Managing partner Martin Einstein counsels local and national companies in connection with their business issues and handles a wide variety of tax issues. Marty is the city attorney of the city of Lewiston and also a certified public accountant. Marty, would you like to unmute yourself and say hello?
So you can tell I'm old enough that it takes me about 5 minutes to react technologically, so I apologize for that. Hello, everyone.
You're doing great. You're doing great, Marty. And then I know that you've got Mike Carey on as well. Mike, anything that you'd like to say by way of introducing yourself or Kevin or any other Brann Isaacson teammates?
Both Kevin Haley and I are here, and we're very excited to be able to reach out and connect with folks in a pretty tough time.
So thank you, and I appreciate it. And you guys were really responsive to our requests for support, so I can't be more grateful than that. Just as a reminder, we got ourselves on mute, and I would love it if everyone would use the chat function to ask any questions, and I'll try to raise them up for the gentleman to answer for us. Is everybody working so far? Can we get underway? Any tech difficulties anyone needs to troubleshoot?
I feel like I should say something just to make sure everyone can hear me.
I can hear you. You
Okay,
should maybe
good.
Introduce yourself and not let Mike steal all your glory.
Oh, that's okay. That's what Mike does that all the time. So,
Welcome, Kevin.
just kidding. Yeah, so I'm Kevin Haley. Been at Brann Isaacson since 1995, and have a general practice in the area of commercial and corporate law. I'm going to be talking about some of the impacts of the COVID-19 outbreak on, business relationships that people have with lenders and customers and suppliers and so forth.
Thank you. I appreciate that. I'm going to get out of the way and let these gentlemen start with maybe kind of where we are currently in the landscape, how that's changed, and then some of the questions that you're hearing. And if we don't get questions from the group, which I think is probably highly unlikely, then I'll follow up with some of the questions that we've been getting emailed here at the chamber. So off to you, gentlemen. Marty, are you going to start? Here, let me unmute.
Sorry, actually, I think Kevin's going to start. I'm going to wrap up. Thank you.
Yeah. Great. So I want to talk primarily about three different things that are all sort of related to that topic of how this outbreak has impacted the legal relationships that different businesses have. So the first topic that I want to touch on is the sort of specific impact that a pandemic has on contractual relationships, and many people have heard the term force majeure. So we're going to talk about that a little bit. We're going to talk a little bit about insurance, because that is a question that we get frequently. Am I covered for this? If I have to close, do I have coverage? That type of thing. And then the third thing that I want to talk about is sort of a more general problem-solving approach that you can take in different places where there are some resources that are available, including some references to some specific things that have happened, and maybe some ways to keep abreast of really fast-moving events in that area. So that's kind of those are the three things that I was hoping to talk about, and and hopefully you all will hold me to that if we get steered off course by questions or what have you. So to talk about force majeure, specifically in the insurance piece of it, which in a way is the kind of most narrow aspect of it. Many of you have seen at the back of different legal agreements that you've entered into over the years, a provision that often is entitled force majeure. FORCMAJEURE is how that's spelled. And what that relates to is the impact of a significant event that was nothing that could have been contemplated by the parties at the outset of the agreement, and the impact that those types of events can have on the legal obligations of the parties. Usually there are two different aspects to it. Aspect number one is, well, what exactly is a force majeure event? And then aspect number two is, what impact does that event have to have on the parties to the agreement in order to give rise to relief from their contractual obligations? So, and we've had a bunch of clients that have dealt with this issue starting probably just about a month ago. We started getting questions from clients who were trying to decide whether to cancel conferences or other events that they had contractual obligations around, and how that all plays out. So it is a safe assumption that the COVID-19 outbreak constitutes an event that would qualify as a force majeure in the same way that a flood would, or a fire, or an act of war. It's fairly clear that a pandemic would qualify. The next question then is, okay, so fine, we have a pandemic. Does that get me off the hook? And in order to answer that question, you need to know a little bit about what the specific language of your agreement says. But most of the time, you're looking for an element that includes either making the performance of the agreement impossible, impracticable, or prohibited by government authority. So to give you a real world example, won't identify the client, but we have a client who's a trade association that was planning one of its large conferences to occur in a northeastern city, which was an early outbreak location for COVID-19. And our first communication with the hotel chain was that we intended to terminate the agreement based upon the force majeure provision. And the response that we first got, this would have been the first week of March, or last week of February maybe. The first response that we got from the hotel was that the outbreak did not render our performance under the agreement impossible, and so therefore they did not agree that the force majeure provision applied. Within 10 days of that first communication, less than that I think, Governor Baker in Massachusetts had issued an emergency declaration that outlawed gatherings of more than 250 people. So at that point, even the hotel acknowledged that our performance under the agreement would have been illegal. And so that caused everyone to agree at that point, okay, the force majeure provision applies, and therefore we're off the hook. So that's an example of how that kind of provision works and what the usual, substantive aspects of it might be. There's also a common law version of the force majeure provision. If an event occurs that was not within the contemplation of the parties, and it renders performance by one or the other parties either impossible or impracticable, which is a super annoying legal term of art, which basically means something has changed which causes the performance of the agreement to be, if not technically impossible, at least would deprive one or the other of the parties from the benefit that they had intended to receive as a result of that agreement. And that often would apply even if you have contracts that don't have force majeure provisions in them. So that's a sort of super quick tour through the concept of force majeure. A word about insurance. Business interruption insurance is typically included as part of a sort of standard hazard insurance policy that a business might. Sean, are you waving at me?
I am. Can you hear me okay?
Yes, I can, yeah.
Before you move on from force majeure and contracts to insurance, I just wanted to, so as a good attorney does, you speak in attorney language. So I want to ask a couple clarifying questions in layman's terms, just to make sure that everybody is on the same page. And I'm happy to use us as an example here at the Chamber. Our basic business is events and social networking. And right now, those are the two things that are generally outlawed. And so I think for those of you who might be joining the call and are trying to figure out about what's legal and what's not and what contracts. So we have contracts in place for breakfast every month, as you might imagine, right? And so to use some concrete examples, it sounds like breaking any of those contracts that we wouldn't be able to do because we're following our state or federal law, and the way that it changes makes us able to get out of those contracts.
That is generally true. Now, not all of your agreements are necessarily going to have that special magic language in it. I think it just makes everything clearer if those contracts do have that provision, which is it's a fairly common provision, but not every agreement necessarily has a force majeure provision in it. But I think it's nevertheless the case under the general law of contracts, whether it's in the document or not, that if local public health authorities have issued an order, or the governor for that matter, that literally would cause your meeting to be illegal, that you do not have a contractual obligation to honor that contract.
Thanks. That's really helpful. Did that clarify for folks? Any other questions about force majeure or contract? Good nodding. Don't forget the chat box if you have questions.
Right.
Okay, on with insurance.
Great. So business interruption insurance, and I'll be brief about this, and I'll skip to the end of the story, and then I'll tell you quickly how we get there. For the most part, business interruption coverage is not likely to provide a solution for folks to the COVID-19 outbreak. If the loss that you're hoping to get coverage for is, well, I had to close my business because the governor ordered me to do so, and therefore I don't have income from my coffee shop, from my retail store, from my whatever the business might be. And the reason for that is business interruption coverage is a characteristic of hazard insurance policies generally. So they, for the most part, need to be tied to a specific casualty loss. So the classic example would be if your coffee shop has a fire, which causes you to have to close, your business interruption coverage might replace some of the lost income that you would otherwise have had because you're deprived of the use of your actual physical space due to the damage that the fire caused. In the early 2000s, there was a spate of business interruption claims that arose out of the SARS outbreak that occurred, that some people might remember from the early 2000s. And the hook that those claims were based on was the possibility that your place of business might actually be contaminated by the virus. And so therefore you need to close. In the immediate aftermath of the SARS outbreak, the standard forms of agreement that the different insurance companies use were changed so as to exclude the possibility of a claim based upon contamination by a bacterial or viral agent. So your standard business interruption coverage now excludes coverage for contamination by a virus. So the only folks that are likely to have business interruption coverage as we sit here facing the COVID-19 outbreak are businesses that have specifically negotiated for coverage of that risk. And that insurance tends to be very expensive so it would be companies that are in the event space, for example, that might undertake to get that kind of coverage. But if you don't know that you have it, I mean, everyone should look at their insurance policies. I should have said that first. That's the first thing that everybody should do. But it's likely that if you have this coverage, it's because you made a specific decision to purchase it, and it's probably pretty expensive. It also may have coverage limits that are much less than your overall hazard insurance policy limits. So it's worth taking a look at that and talking to your insurance professional about it. But it is certainly not a widely available solution to COVID-19 closure issues. So any questions about the business interruption aspect of it? That's really all that I intend to say about that, unless people have specific questions.
So we'd know if we were covered, but we should double check.
Yeah, I think that's the takeaway. You probably would know if you had this coverage. Yeah, exactly. Good. All right. So then the final topic that I sort of want to cover are the different tools that are available to folks. Some of these have been enacted in the last week or 10 days by state and federal governments. And some of these are pre-existing. And one general point that I would make about the tools that are available to you is that they are changing every day. I mean, if you're paying attention to the news this morning, we know that the Senate is debating a third piece of very significant COVID-19 relief-related measures That has not yet become law, but something is likely to become law within the next 12 to 24 hours. And that may have a significant impact on the different tools that are available to you. So one thing that I think that business owners should be doing is paying very close attention to reliable sources of information about what various government agencies and legislative bodies are doing, both at the state and federal level. It's important because these things are happening in real time. It's important to maintain a link to sources of news about that. And I know the Chamber has some great links on its website to different agencies that have specific areas of responsibility in all of this. It's also, I know there are a lot of state legislators who are doing a great job getting information out about what's happening in Augusta. And those are all really important places to be paying attention. Yeah, go ahead. You were about to ask a question, I could tell.
No,
Yeah.
You're doing great. I would just say on that note, we're taking the information very seriously. And so we're connected with our federal, state, and local officials. We're getting that information as soon as it comes in. Both Lewiston and Auburn are taking some unique steps as well. And so what we're finding is it's hard to go to one place and find all that information. We have created a website just for this, which is laadapts.com. And you can go there for community resources, business resources. We're posting all of the changes in federal laws and direct links to verified, reliable sources of information. And it's one of the few places that you can get all of that as well as the local information. And we are sending that out in regular emails when there is something new to share. So we're not sharing emails with you if there isn't a good purpose. So do keep opening them because we're pretty committed to that.
Great, that's super helpful. And I know there are other organizations around the state that are doing the same thing. So that's good to know. The other general point that I would make is that this is a time for small businesses to be thinking about being proactive and engaging with your customers and your suppliers and people like your landlord and people like your lender. And although there are lots of specific relief programs that are in place, and I'll run through just a couple of those here as I close in just a minute, there is no substitute for picking up the phone or sending an email or sending a text to the people with whom you share significant commercial relationships. Everybody is trying to figure out how to build a bridge to the other side of this crisis. And you should not assume that your landlord is going to insist on getting his rent paid on the first of the month, just like nothing was happening. Your landlord is incented to make sure that you don't fail. Now, you may or may not have a legal argument that you don't need to pay your rent, but I think people are in problem-solving mode, and so you should leave no stone unturned in terms of trying to figure out what makes sense with important stakeholders for your business. So landlord would be one really important topic to cover there. The other would be lenders. I mean, I think you want to make sure that you are reaching out to your lenders to understand what measures they may have in place. And there are some things that are happening with the economic development agencies and the state and federal government that are relevant to that. But again, if your lender is, say, Bangor Savings Bank, call your loan officer because they probably have a plan that may very well enable you to avoid having to make that payment when that day comes next month. But if you don't call them and ask, then you won't necessarily know. So that's really important. I think everybody should be doing that. I can say that based on some of the things that have happened in Augusta and in Washington over the course of the last couple of weeks, there are some specific things. Places to look. I know that the Finance Authority of Maine has a half a dozen different COVID-19 specific programs that you can apply for through the FAME website. And those range from individual loans to individual consumers of up to $5,000, which maybe is not going to be relevant. Well, it might very well be relevant to small business owners, but it also might be relevant to your employees. and the amount of that loan is reduced by the amount of any unemployment benefits that they might have received. There are also SBA disaster loans that are available. That's the same species of loan that the SBA makes available sometimes when there is a flood or an earthquake or a landslide or something like that. Disaster relief has been made available for COVID-19 impacted businesses. FAME also has $50,000 bridge loans that are available to people who are in the midst of an SBA financing process, but are not able to access that money right away. And the FAME website says that those loans can be had and funded in as little as 48 hours. So that's a potentially powerful and almost immediate tool. But FAME and SBA are two good clearinghouses for information about specific financial programs that are available to business owners. And so I would encourage people to be exploring those opportunities. So I've talked for longer than I thought I would. Sorry about that. But if you have any questions about any of that stuff, I'm happy to address that.
Yeah, and I'm going to put, I had a request for the LA Adapts website, so I'm going to put that into the chat box for everybody. There's just a couple things that I want to point out, Kevin, about what you said that's been important to reinforce. Like you, I'm spending a lot of time on calls with commissioners from DOL, DECD, Maine Office of Tourism. We're staying in the loop on all of that information, and there's a couple of things that we've found helpful for folks to note. And so, and this might not be you, this might be somebody that you're working with through your business, but right now sole proprietors have not largely been addressed in most of the legislation that has come through. The one that Kevin mentioned is the state of Maine is offering, and it's actually free $5,000 payments that you can get over the so it's one of the few places where some funds can come in for people who might be contractors or sole proprietors of a business. And then the other thing that I would just flag is you can absolutely go to the FAME website, and we have that listed for you in the LA Adapts, or go to the FAME and you'll see their kind of red coronavirus spot at the top. But what I would name is that the FAME money is going to be flowing largely through your financial institutions. And so what we've heard over and over again, and this really just goes back to Kevin's advice, is go directly to the institutions that you already have a relationship with, not just about your current concerns or next month's concerns, but they're the exact folks who are going to be the distribution channel of these funds through the state. That's not the same yet for the federal funds, obviously. SBA, you're still going to want to go through SBA, but that's where they're encouraging folks to go to. And then the last thing that I'd note is for folks who might not be sure, SBDC is also assigning counselors to help you go through the SBA loan program. SBDC.com, request a counselor, and they'll actually help you for free walkthrough. So those are just a couple of things I want to highlight about what Kevin said that I think is really important to get out. Are there questions? Mike, is there anything that you would chime in or add?
I can talk about a couple of the employment. There's two new bills that have really changed some tools that are available for employment relationships that I can talk about if this is ready to move to that, Shannon.
That'd be great.
So I'm going to talk about the last actions taken last week by both the federal and the state government. And I'm going to talk about 3 ways in which those bills will affect your employment relationships. It could affect your relationships with your employees. I'm going to talk first about the federal bill and make clear something that Kevin talked about earlier. This is the bill that originated in the House and was signed last Wednesday. This is not does not take into account what is being negotiated today. And in fact, some drafts of the bill that's being negotiated today would change some of the things I'm about to talk about. So the federal legislation, and I'll start there, it does 2 things. It provides a new emergency paid sick leave benefit. And it's an entitlement to employees. And it also temporarily expands the Family Medical Leave Act. So first, I want to start with some common elements for both of them. And so first, which businesses it applies to. Both programs apply to private sector employers with fewer than 500 people. There are some exclusions for employers with fewer than 50 people, and I'll talk about them because they're separate for each of the programs. And there also, and this is one of those places that Kevin mentioned, that there may well be equivalent credits available for self-employed individuals. I'll talk a little bit later about when some of that will become a little more clear. For both programs, there is a tax credit available against payroll taxes. It's dollar for dollar what the business pays out, it will be able to get back in payroll tax credits. These are refundable tax credits. So even if you don't have a payroll tax that you're paying, you can apply to have the refund sent, and the IRS has put out a guidance on Friday that they will send it as quickly as possible. So that the guidance from this, or the regulations from this, is supposed to come this week. We were watching the website every day, and today it said it's not going to come till April. So it's kind of highlights that this is a fluid time, but we do expect guidance both from the Federal Department of Labor and from the IRS. There's a 30-day non-enforcement period, as long as the employers are trying to engage in good faith compliance efforts. So this is certainly not something that can be ignored, but both agencies are going to be focused on trying to help people comply, trying to help businesses comply for 30 days after the effective date. Now, when does it take effect? And this is a big question. The bill was passed last Wednesday, and it must take effect within 15 days, though can be earlier. Our best guess right now is that they will use all of the 15 days and will take effect on April 2nd. That may change. It's also not clear whether it will apply retroactively. So what to do and how to negotiate the 2 weeks before it starts is one question. So first, I want to talk about the emergency paid sick leave portion of it. And this is fairly straightforward. It requires employees, this is an entitlement, to give 2 weeks of paid emergency sick leave that's related to COVID-19. First, I'm going to go back to what I talked about before. And in addition to private sector's employers under 500, this also applies to all public sector employers. Now, I want to now discuss one of the exemptions for employers with fewer than 50 employees. Is the Federal Department of Labor is authorized to exempt employers from having to comply with this if the absences are related to caring for a child whose school or childcare is closed. So so in terms of which employees are eligible, there are 6 different reasons for which employees are eligible. And so one of them is caring for a child if the school or childcare is closed. And so the exemption is only by the Department of Labor and only relates to, excuse me for that, as you can see, I'm dealing with some closed childcare as well.
So many of us are parenting and working, Mike, you're doing great.
Only relates to that exemption, that reason, excuse me. But the 6 reasons are fairly similar. You need to go. Thank you. They're fairly similar. They cover situations when the employee is eligible for payment if the employee misses work because of their experience with COVID-19 or the experience of someone they're caring for who's experiencing COVID-19 in some way. So how much time are employees entitled to? Full-time employees can take up to 80 hours of paid leave. Part-time employees can take the equivalent number of hours that they would typically work over a 2-week period. Now the wages that are eligible to be paid under this, and this is different for both of the programs. And here there's a difference for if it's the employee's own condition. And so as I mentioned before, there are 6 different reasons that employees are eligible to take paid leave. If it's for the employee's own condition, it's paid at 100% of the employee's regular rate up to $511 a day. If they're caring for another person, whether it's someone under quarantine, a child home from school, they're paid at 2/3, 67% of the employee's regular rate, up to a far different cap, up to $200 a day. So the cap is $511 for if the employee's own condition, and $200 if it's caring for someone else. Now, and I'm sure there may be questions about how these different programs interact. Here's another wrinkle of that, is the employee has the right, but may not be required, to use additional paid sick time that they may have earned through normal policies before dipping into this. They can either use the emergency time available, or they can choose to dip into the accrued time that they have. So now I'm going to go to the expansion of the Family Medical Leave Act. And again, start with which businesses it applies to. So again, it applies first to all private sector employers under 500 employees, except the exemption for employers under 50 is the Federal Department of Labor can exempt small businesses if it jeopardizes the viability of the business as a going concern. So I'm going to say it again. The Department of Labor is authorized to exempt. We don't know yet how they will do that, or if they will, for that matter, if it jeopardizes the viability of the business as a going concern. In terms of which employees are eligible, the employee must first have worked 30 calendar days, and this is so in the paid sick leave benefit, it was quite broad, and there are 6 different reasons. Here, this is only available for employees who are unable to work or telework due to a need for leave to care for children whose school or daycare is closed, or whose child care provider is unavailable due to the public health emergency. So this really is, the Family Medical Leave extension is only for child care, and it's children under 18. So there's not a limit to the amount of time that the person is entitled to, however. And in terms of the wages, how much they're paid, the first 10 days will be unpaid. And then thereafter, they're entitled to paid leave, again at 2/3 of the normal rate, and again capped at $200 a day. So again, the employee has the choice. They may choose to use accrued time that they have in lieu of the family medical leave, or they may choose to use the family medical leave. The statute addresses whether or not the employee's job is protected if they use family medical leave in this, for this reason. If the employer has 25 or more employees, the job is protected. If they have fewer than 25 employees, it's a little more complicated. There's no protection if the job no longer exists because of COVID-19 economic conditions. But the employer must make reasonable efforts to restore the employer to another equivalent position, and there's some similar stature, similar pay, similar benefits. And if those efforts fail, then the burden on the employer continues for 12 months. The employer must make reasonable efforts to restore the employee to an equivalent position if that becomes available over the next 12 months. So now I'm going to pause and see if there's any questions on this first before jumping into the changes to the unemployment insurance that the state government passed last week. All right, I'll jump in. So this is a follow-on in tandem with Governor Mills' state of emergency in the state of Maine. And so for the duration of that emergency, there's a new statute that governs certain types of unemployment insurance claims during the COVID-19 epidemic. So for the employee to be eligible for this temporary benefit, this temporary ability to claim unemployment insurance, the employee needs to be able and available to work. They need to maintain contact with their employer and qualify. They're either out of work because of a temporary medical quarantine or isolation restriction, or they're temporarily laid off due to a partial or full closure of the place of employment because of the state of emergency. And so a classic example here is a restaurant that may have had to close because of the governor's subsequent order. That is, employees are eligible for this unemployment benefit, even though they may still be, and the employer may still hope to open when that is over, or resume full employment when that is over. Very important for employers. And I guess, before I go to there, the language around, we have not yet seen circumstances in which employees are told to remain home for quarantine. This is different than other states that we've seen. You know, for example, California has a stay-at-home order. So is a little bit unclear about how this statute will qualify if there is not if there's not a doctor's note that the person can't stay. So this is a place where if you're considering this and considering how to plan through this, you'll want to talk with counsel to make sure that you kind of to puzzle that through, because that may well change as well, obviously, as the circumstances change. And then finally, as this will not be charged against the experience rating for the employer. And so this is it appears here that the legislature and the governor were trying to make it the employment relationship relatively flexible, dealing with these circumstances that we're all facing in this period. And so this is it's not odd, I guess, that we're having this conversation now while the Senate is negotiating and the House of Representatives are negotiating a third, potentially the largest stimulus bill ever in this country. This may well and will likely change. As I said, as I started, some of the federal benefits are implicated by some of the drafts of the legislation that are under negotiation, and there are some interplay, although it likely won't affect the employment relationship. There's some interplay with unemployment insurance as well in those bills. Again, as I mentioned before, the Federal Department of Labor has not yet issued regulations on last week's bill. We expect that to occur this week, and we'll be in touch with folks when it does. And I think I think I'll close here with something very similar to what Kevin said. This will pass, and when it does, businesses are going to grow again based upon your relationships and upon the relationships with your employees. And these are some really powerful tools to use to help kind of bridge the gap from now until then. The ways in which they work together will be complicated, and we may talk about some of those, but you really will want to kind of reach out and get some advice as if you're contemplating an employment action.
Mike, can I ask a question about employment law? Please. This is a question that came up from a member of my social circle who's trying to navigate these new changes, but there's somebody who has an underlying condition that makes it dangerous for them to leave, right? So they're very much qualified as you must self-isolate. They have COPD and chronic bronchitis. They're an hourly employee through a school department, and the school department is paying for all of the regular teachers and administrative staff, but for the hourly employees to continue to get paid, they must come into the school district and photocopy packets and pack food lunches for the buses. And it's not a reasonable request for this individual. And of all of the information that I've seen, it seems like this person, because they do not yet have COVID, or they're not caring for somebody who has it, that they're really trying to figure out, do I have the right to stay home? And if I do stay home, then what? And as you can imagine, telling that individual to contact their doctor right now isn't working well, because our healthcare system is kind of breaking down. So in that regard, suggestions, clarity, anything you can bring to that?
I mean, and so one of the challenge obviously is this person clearly is facing an issue today and tomorrow, and the federal entitlements are not yet have not yet enacted. It's I mean, I think the first place to start is the conversation with his or her employer. This is this is something the entitlement under the state unemployment system exists if there's a doctor's note. That circumstance, as you point out, is something that is more difficult. So I think this place to start is with the employer. See if see where that conversation goes, because this is a fluid time in there, and it sounds like there may also be some kind of existing employment law with it that's implicated here. So that's that's where I would start.
Thanks, because I think that's been part of it.
Yeah.
Other questions while we have these folks with us? We've got another like 10 minutes and I don't want to.
I did want to add a couple things, Shannon, if I could.
So, please do. And I will note, because you guys had asked me to do it, that you had wanted to make sure there was time reserved for Q&A. And so just letting you know.
Yeah, I'm sorry. So I'm sorry to interrupt, but what's very difficult for a lawyer is to come after two other lawyers. Because they always take more time. It's sort of like being on Capitol Hill and being between a congressperson and a TV camera. So I'm sure you're in a rush to get over and done with this, but so bear with me for 5 minutes. I won't talk about substance. I won't bore you with details about the law. I will talk about process. So I'm the gray hair of the crowd. And I've been through different crises, a lot of crises, nothing quite like this, but we've had the 9/11 crisis, we had 2008, and we certainly had in Lewiston, Auburn, the post office locating to Portland. I was chair of the Lewiston Auburn Economic Growth Council, and it was quite a situation. And I sort of feel now like Lucian Goslin, if anybody knows what that is, and that's kind of a tough feeling. To be the elder statesman of the group, but I guess I am. So the important part when you go through this process is stick to the fundamentals. Who are your stakeholders? I think both Kevin and Mike talked about it. You have three stakeholders. You have your employees, you have your customers, and your vendors. And you cannot put your head in the sand. You have to reach out to each one of those stakeholders and say, we're here, we're surviving. What can we do to work together? That's the most important lesson. I say that as a business person. Internally, cash is king. Take stock of your cash situation. I've counseled companies that have gone through financial distress. This is a different form of distress, but everything goes to the run rate. You may have heard the term run rate, but it's an important term. And what that means is you want to know what your absolute cash expenses are and how much cash do you have on hand. Do you need to reach out to a bank or your friendly lender for one of these programs? It's not so easy. You hear about FAME, you hear about this and that program, but to get a loan on a short-term basis is not so easy. So the first thing you ought to do is put on your green eye shade and look at your cash situation. See what your financial needs are, your cash needs are in the near future. What's really interesting about the federal act, the so-called Families First Coronavirus Response Act, the mandated sick pay, an employer naturally would say, how do I realize that I'm going to get reimbursed through a tax credit, but that's sometime in the future. How do I actually write a check to my employees? And what you need to know is, what I've determined through contacts is that the Treasury Department issued an announcement, and I think it's good as gold, but you need to look at the details. And that is that you can hold up your tax payments to the Treasury for employment tax. You have to verify that, confirm that. Don't rely on just my statement, but that is an important feature. So instead of remitting the withholding and the other employee tax that you normally are required to do under penalty of jail, you can hold those up. So important that you look at the details to make sure that is the case. If that is the case, that is a source of cash. Of course, your tax payments that you would otherwise be obligated to make to the federal government are another source of cash. The federal government has deferred charging tax for self-employed, for estimated tax, and for federal tax 1040 purposes. In addition, you should, unfortunately, the state has not done that, but other states, if you do business in other states, make sales in other states, they've given you a free grace period of making sales tax payments to other states. So there are all sorts of mechanisms out there, and all rotate around the question of cash is king. Look at what your cash is, how you discharge your obligations. It's sort of like when we were kids and we would look at our piggy bank and what's in the piggy bank. That's what you have to concentrate on. Reach out to your customers, look internally at what your cash is, talk to your advisors, and see what is the best course of conduct for you. Because as Mike said, we're going to get through this. This may be an unprecedented crisis, but we will get through it. But you have to keep your framework intact. And to do so, you have to write a check sometimes. And you want to make sure you have enough money in the bank to write that check. So with that, I've completed my spiel, and I'm happy to answer any questions, as are Kevin or Mike.
Thank you. There's a couple of links that I'm going to share that goes to documents that were shared with us by Brann Isaacson in advance. So I'm going to put that in the chat. I also wanted to say that there was a good question. Yes, we are recording this and we'll make it available afterwards in case you want to replay any of these juicy tidbits. Look at any of the links that we shared in the chat. So we will make it available, and we'll be sending a follow-up email to everyone who registered with the attachments as well as additional information. And Mike, I think you were going to take Chris's question about
Sure.
employees who live in other states. And you might just want to restate the question for anyone who might not have seen it in the chat box.
Yeah, so Chris, as I understand the question, and let me know if I don't, the question is, how does a main employer respond if an employee who lives in another state is laid off temporarily because of COVID-19? Are they eligible for unemployment insurance?
No, it's if the other state tells people to stay home, but Maine hasn't.
So if you're a Maine employer and you have an employee from New Hampshire and the New Hampshire employee is in a shelter-in-place order, what requirements do you have for that employee who's living across state lines?
Right, like Massachusetts just did that this morning or yesterday or something, so.
It's a great question.
I'm probably dealing with
at this point, I think that, this obviously is a question about the state government and the obligations the employer has to state government and the Maine state government. So to talk about the unemployment compensation piece in particular, first of all, it depends on the specific facts of what's happening, but the employer can't require the employee to violate an order to stay home. So whether or not they're eligible for unemployment insurance likely depends on whether they were doing work in Maine. Whether their unemployment insurance in Maine likely depends on whether they're doing work in Maine, and so it's going to depend on things on whether or not the employer, for example, was paying into the fund. I think it's going to be a pretty fact-dependent thing, but I think generally there's a good chance of it, and I think it's a question that I'm sure that the state will be dealing with as they put guidance out or issue advice.
And before we lose anyone else, I just want to give a little bit of a plug. There's a lot of conversation on the topic of employment, and as Mike had already pointed out and a couple others, it's going to change. It's going to change today and tomorrow, likely. I think we're just going to be in a fluid environment. The good news is we have got them coming back to us tomorrow at noon, specifically for another webinar just on employment. So go over and register for that on the Chamber website. You'll be able to see it, or I sent links in this morning's email. And we'll make sure, same deal, that you get the information that you need, that you have a chance to ask questions. We'll share those documents. We'll record it if you're not able to attend. But I think there's a lot of conversation to be had on employment. And so we had anticipated that and made additional time for that in a second follow-up session tomorrow. Note in the chat function that I sent 2 links that you can get the overviews shared with us earlier by Brann Isaacson about what they're talking about today, which should answer some of those questions. And we'll be making those resources available in a follow-up link. So in the 2 minutes that we have left, was there any other questions that you were burning for? how did you find this? So I'll be really honest with you. You all were guinea pigs. Today was our first day being able to try a virtual learning session. We're going to be doing more of them, particularly around these topics as the landscape that we're all operating in changes. I welcome your feedback, both on the Chamber's performance and on this format and how it felt for you. Thanks, Ed. Appreciate that. Okay. You can unmute yourselves if you have something to contribute. Would love to hear it. Well, then join me in giving our attorneys from Brann Isaacson a kind of virtual applause. Thank you to Marty, Kevin, and Mike, who were really quick in reaching us and offering this opportunity. And I'm sure that there'll be more to come. So stay in touch. If you have anything you need, reach out and let us know. And thank you each for being members and for doing your part in community right now. We're grateful for it.
Thanks, Shannon.
Have a great
Nice.
day, everyone.
Thank you.
Oh.
Thank you all.
Thank you.
Be safe.